If you live in Thailand or just happen to be following the news in the country, then you're probably all too familiar with the shenanigans surrounding the candidacy of Khun Pita Limjaroenrat as he attempts to become the country's next prime minister. Regardless of how the vote plays out, his fate is ultimately going to be decided by the Constitutional Court, which could disqualify him from not only being prime minister, but from holding office in general. However, doing so would mean the Constitutional Court would need to reinterpret or possibly redefine existing laws regarding inheritance. It's a complex situation that dates back to the passing of Khun Pita's father, who left behind a fairly sizable estate, including shares in a defunct media business. As son and heir, the current candidate for prime minister was named as the estate's executor. But what is an executor exactly, and why may it determine the next prime minister of Thailand? Here's the answer to those critical questions. Anyone creating a will in Thailand must name an executor to fulfill their wishes upon passing. Usually, a beneficiary is named to this role as opposed to a third party, since this individual knows when the person has died as well as where the assets are located. The executor receives a court order that allows them to go to the relevant authorities to transfer and distribute the estate according to the will. In typical cases where there's only a handful of heirs and a reasonably sized estate, this process takes anywhere between 6 months and a year to complete. However, larger estates with many heirs can take longer to disperse, especially since the executor may have other obligations to attend to. Larger estates can also cause problems if the deceased has assets not included in the will, since the executor and most other parties involved don't know what to do with these. That brings us to the current case against Khun Pita, who finds himself in limbo regarding what exactly the responsibility is as it relates to the executor of an estate. Does an executor own non-dispersed assets of an estate? This is the million baht question at the moment, and it is what the Constitutional Court is currently mulling over. Khun Pita argues that an executor does not own the possessions of the deceased outside of what is stated in the will. Since the media business shares are not stated to be his in the will, they were never transferred or in his possession at any time and are still waiting to be dispersed as part of the estate. The opposition argument is that as an heir and executor, the media business shares are owned by Khun Pita. This runs afoul of rules regarding prime minister candidates in Thailand and meant he should have been disqualified from running in the first place. What does Thai law have to say about all of this? Nothing really. That's because it hasn't been an issue before up until this point. And if we're being completely honest, the only reason it is an issue today is because, well, politics. The law as it currently stands doesn't clearly say one way or another if an executor owns possessions of a deceased party not mentioned in the will. That puts the Constitutional Court in a bit of an awkward position. A ruling against Khun Pita would unlock a slew of unintended consequences as it relates to inheritance laws in the country. This would ultimately make it much more challenging for anyone to be an executor and is probably not ideal. We still look to be in the middle of what is shaping up as a very long saga, something not unheard of in Thai politics. Between the vote for Prime Minister, the Constitutional Court case, and a host of other issues, it really remains to be seen just how it plays out. Hopefully, this gives you a better idea of what exactly an executor is as it relates to succession planning in Thailand, as well as some background on why it may be crucial in deciding Thailand's next Prime Minister. That does it for me. I'm Cheyenne Hollis. This is Interesting Asia, and as always, keep it interesting.